Beaverton School District special work session on Monday, October 22nd, 2018. We ask that you all silence your cell phones at this time and take any personal conversations outside. At this time, I'd like to introduce Megan Farrell, a consultant hired by the school board to assist with Title IX sexual misconduct compliance review of procedures and processes, including a recommendation and or revisions to ensure compliance with laws and practices that enhance compliance. So Megan, the floor is yours.
Great. Well, thank you very much for having me. It's really nice to have had this opportunity to work with Beaverton School District. I can say for sure that you have a lot of very dedicated professionals here who really want to do the right thing around Title IX. So my background is I've been working in Title IX since at least 2001, and even prior to that, before we were calling student-on-student sexual harassment Title IX. And I'm currently the Palo Alto Title IX coordinator. I'm a standalone Title IX coordinator, which is somewhat unusual, although I'm seeing more of those in my work. And I had the opportunity to go through a bunch of your documents and also meet with people and hear what people have to say. So with that, I'm just going to get started with my presentation, and then I'm happy to take questions as we go through and or questions at the end. So just an overview, I'm going to just talk a little bit about the scope of what I reviewed, a little bit about the documents because there are quite a few of them, and then talk about Title IX sexual misconduct for educational institutions, and then some recommendations that I have going forward. So this is just the scope, review policies, procedures, and practices of Beaverton related to sexual misconduct, including sex, gender discrimination, harassment, prohibited under Title IX. So I took a look at a number of your policies, both sexual harassment procedure, non-discrimination, discrimination complaint. I won't read through all these, but I looked through all of those policies and also a number of other documents that touched on some of these issues, including the Code of Conduct for Professionals, the Parent and Family Handbook, the Board Handbook, a document called Student and Staff Boundaries, as well as reviewing the Westview investigation file, which is probably one of the largest investigations that the district has done. And then also the most recent Title IX self-evaluation, which focused on athletics. I also had the opportunity to meet with and look at the policies and procedures and processes and practices that are in place for human resources. There's a number of documents that have been developed to assist people with investigations, templates and form letters, things like that. And then also the teaching and learning lead on this talked about how they deal with student respondents. So issues involving allegations brought by students against fellow students is handled through teaching and learning, and then allegations where the employee is a respondent, a student brings a complaint against an employee, that's handled by human resources. I had a chance to meet with a number of board of directors when I came to the district offices, and then also some administrators here at the district offices, including human resource professionals, Title IX officer, and the head of the HR. I also had a chance to meet with school administrators, so we had a group of principals and assistant principals from the high schools as well as from the middle schools, who all brought a great level of enthusiasm for doing the right thing around students, around these issues. There was a knowledge of Title IX without necessarily putting it in the box of Title IX, is what I would say. I think there was some confusion, and I'll mention this later, around Title IX extending beyond the scope of athletics, which I know there have been a number of issues at this district where that has come up. But there was definitely a bit of a perception around Title IX being limited to athletics. So Title IX, what it says is no person in the United States shall, on the basis of sex, be excluded from participation in, being denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. So that was passed in 1972. And then there was some guidance that came down from the Supreme Court in the late 90s, two important cases that basically said that there are private right of action under Title IX, and also that there could be financial benefits to a complainant bringing something forward under Title IX. The most relevant guidance as we're looking at it today, and we're all kind of sitting on the edge of our seats waiting for additional guidance, which I was just at a conference this last week where they said it won't be a full year before we really actually have that additional guidance from OCR. There's a typo in this first bullet under Office of Civil Rights. That should be the 2001 guidance, not the 2011 guidance, because the 2011 guidance was retracted, so I apologize for that. The 2015 Dear Colleague letter, and that's a lot of guidance around what a Title IX coordinator should do. And then the most recent guidance is 2017. It came down in September of 2017, called the Questions and Answers on Sexual Misconduct, which had altered some of the guidance that had been leading us since 2001 and gave us some insight into how this administration is going to handle Title IX. So the 2001 guidance, this is guidance that has been codified in regulations, and it talks first about designating the Title IX coordinator at schools. Quite frankly, my experience was 2001 came and went, and not many people had designated that Title IX coordinator until 2011. But that was something that was in the regulations since 2001. Then the requirement that you adopt a grievance procedure that provides prompt and equitable resolution for complainants, and harassment and prevents its recurrence, and then remedies the effects of that harassment. My review indicated that there is a Title IX officer here at the district, and that is available on your website, so that's important. If OCR were to conduct an investigation, they certainly would go to your website and put in Title IX coordinator and figure out whether you have somebody here doing that. With regard to prompt and equitable resolution of complaints, there are a number of policies. The ones that I reviewed all had a bit of Title IX covered in it, so there was something about sexual harassment that could really be covered under, for instance, your sexual harassment policy, but also your non-discrimination policy, and also your cyberbullying policy. So it's possible that people could be confused about where to go, or they could select one of those avenues to go to because they feel it might be more beneficial to them. So that was a little bit of a challenge, and I'll talk about that in my recommendations, as well as equitable resolution of complaints. The process under your non-discrimination process and sexual harassment process, both of them have 4 levels of appeals, and that is pretty unique and unusual. Also, could negatively impact that being prompt, although the time frames in your procedures, things are happening within 5 to 10 days. But because there are so many levels, and because there's so many different ways somebody can go about reaching the final resolution here, some might say that might not be as prompt as others would like. Ending harassment and preventing its recurrence. None of the policies reference the interim measures, and interim measures are what we put in place during an investigation to make sure the person who complains has been is being protected from additional discrimination or harassment. My experience speaking to your administrators was that actually they put a lot of things in place right away, but I think it would be helpful that your policy specifically calls out interim measures and that they would be put in place for somebody who's brought a complaint. There is, under point 2, ending harassment, preventing its recurrence, all of your policies do have a non-retaliation provision, which is important, so to make sure that there isn't any kind of retribution against a person for bringing a complaint. And then remedying the effects of harassment. The policies don't specifically go into what kind of punishment could be applied, and that might be something to consider with your legal counsel as well as external counsel about whether you want to add some detail with regard to that. Under the 2001 guidance, there was also a requirement for periodic training programs for staff on sexual harassment. In some states, that's even been codified as something that you're required to do. There seems to be some training around sexual harassment around staff. I didn't get a sense that it's really a requirement that everyone do that annually. For instance, in California, it's state law. If you're a manager, you have to do it every 2 years. So, of course, because it's state law, we follow it. And then providing support services for complainants. Again, there wasn't a lot of detail in your policies about this, but what I found was that schools were really doing this almost like a knee-jerk reaction. They were getting groups together to make sure that students had support that they needed. The 2015 guidance is the one that goes into a lot of detail about what your Title IX coordinator should do. So there is first some technical requirements about your non-discrimination policy, and as my report goes into more detail, there are a few points that are not found in the current non-discrimination notice that you have on your website, and it is not in some key documents. So the idea is that it should be promulgated as much as possible, so it should be on the sites. The other requirement is that you would put it in certain documents, and so I did see it in the parent handbook, which is great. The student the student and parent handbook includes it, but some of the other documents I looked at did not have it. So the Title IX coordinator role is broader than just having a person at the site, and the 2015 guidance goes into detail that this is the person should have oversight of all of the responses to incidents, looking into Title IX for areas about what's happening, identifying trends, monitoring outcomes, developing training programs, and things like that. And that is where I think I would say that Beaverton could do a better job making sure that the Title IX coordinator, that somebody has broader range of looking at all of the things that fall under Title IX. The 2017 guidance, I mentioned this was under the latest administration, and this guidance, in some ways, for some people, they felt the pendulum was swinging back from being so in favor of complainants and trying to reach some level of balance. So there's a lot of stuff in there about equity, making sure a complaining party and a responding party get the same access to information, they get the same notices, they get process that is applicable to both. Also, this idea of interim measures is available to both parties. So there was, in the past, this idea that complainant only needed the interim measure protection, and now the guidance says you can't just automatically only give that to the complainant, you have to see if both parties need it. What had previously been listed as a 60-day time frame to complete investigations has been broadened to say a reasonable time frame. And then there was a prohibition against informal resolutions that involve sexual misconduct. This guidance says you can do that when you have the consent of all parties. So the basis of that guidance previously was that we don't want to put somebody in a situation where they have to confront someone who's perpetrated some kind of violence against them. But as long as the parties have consented, that is permitted now. And then finally, this is just underscoring what we've seen since 2001, which is this idea that you have investigators who are trained in how to conduct these kinds of investigations. So I'm just going to move to my recommendations, unless anybody has any questions about what I've said thus far. Okay. All right, so I mentioned that I felt that one thing that came up was that there wasn't as broad a view of Title IX here at the district, and I think that that's pretty common, and I think a lot of districts are reactive to what is their biggest Title IX concern. So I'm working in Palo Alto. Our biggest Title IX concern involved a sexual assault that happened at the school amongst 2 students, and that got a lot of focus. I understand that a lot of athletics and the parity in athletics is something that you are concerned about, but I felt that everybody could get a little bit more grounding in the broad scope of Title IX, including allegations against complaining against an employee, but also complaining against fellow students, which is covered. And the data would certainly say that that is an area of high occurrence. Although if you bring a complaint against an employee, obviously, if you're looking at the financial end of a litigation, that you would probably be paying more money for not controlling your employee as opposed to a student. But by sheer numbers, and the sheer numbers that I looked at here, where the data was collected, is that you have much more of an incident on student sexual harassment and sexual misconduct. So that's just kind of the underpinning of this. So my suggestion is that you take a look at that Title IX office and see how you can structure it. So I suggested a Title IX coordinator having responsibility for all of the Title IX enforcement here. One deputy that's dedicated to athletics, because it does seem to need that level of attention here. A second that's dedicated to human resources, and that would be a person that would be dealing with any complaint that comes against an employee. And then a third that would be a deputy that would deal with student-on-student matters. So I think that there is strength in all of these 3 areas that you have here. So you could have somebody be a Title IX coordinator and then be a deputy in one of these areas, have a couple other deputies and have that coordinator sit above all of it. It also is dependent upon who has the time to do it, because it is a time-consuming job to look above everything and be looking for responsibilities and monitoring outcomes and trying to figure out how to proactively address things. Policies and procedures. So first, the non-discrimination statement, a real simple fix that just updates some of the technical requirements. One that comes to mind is the local or super office being a contact that's listed. Policies, inclusions, and exclusions. I know state law dictates a lot around what types of policies you have to have, and often there is overlap, but if there could be a look at all of these things to say, the sexual harassment policy may be covered under non-discrimination policy, but we're going to include a clause that says, if this matter involves sexual harassment, it will actually be handled under this policy, under this procedure. So inclusion and exclusions might help you get to that, a way that you know exactly where these policies are going to fall and what procedure people are going to be using. Sexual violence is not explicitly covered in any of your policies, so sexual harassment and the cyberbullying policies, for instance, don't specifically say anything about sexual violence, so I think you want to add that provision explicitly. Equity between your complainant and respondent. The policy talks a lot about the complaining party getting notice, the complaining party being able to appeal. The respondent does not have those explicit notifications and things like that. So tweaking your policy so that both parties have that. The 2017 guidance actually says you can have an appeal process only for respondents, which goes back to kind of old guidance that was out there. But yours is really explicitly saying the complainant can appeal. Now, if your respondent is a student or an employee, there might be other ways they can appeal if they've been subjected to discipline. But you would want your policy to at least refer to those so you can see that there is that parity for both sides. Your policy doesn't list what the burden of proof is for coming to a conclusion. So the policies don't say preponderance of the evidence, clear and convincing. There's a lot more flexibility now because it used to be all preponderance of the evidence, but you can do clear and convincing. You just want to be explicit about what that burden is so that your investigator would know how am I weighing this to make my determination. The notices, again, some stuff around parity, make sure both parties are getting notice of what's happening as well as the outcome. And then I mentioned the multi-step appeal, I think overcomplicates some of this, and I would say that you should have one appeal process for each policy. And where that appeal falls is kind of up to you guys. I would say that I found it unusual that people could get to the board through that process. That's from the other policies I've looked at. That's kind of that is kind of unusual. So I think even if you want things to get to the board, maybe taking out some of the layers in that process would be helpful. Best practices. One of the things that I would suggest is that there could be some more rigor in your process. So a situation comes up at a school and the school deals with it. And that's fantastic. And that works for most parents. And even the middle school principals and administrators were saying, for the most part, within 24 to 48 hours, parents have been called, discipline has been imposed, things are taken care of. That process is fine for people who want things resolved right away, but there are members of communities that want a little bit more rigor. They want to have an intake process, they want to know what policy is being looked at, and they want to know what that analysis is going to look like at the end of the day about how the policy is going to be analyzed with the burden of proof, for instance, identifying exactly how that decision is going to be made. So I would suggest that you have maybe a flow chart is very helpful. I know I've worked with students and parents to develop one of these to just make it a little bit easier. I think sometimes these infographics make things a lot easier to understand. I know I drew an infographic when I was trying to figure out your appeal process because I was like, now what do we go? Then we go here. So that might be something that would be helpful and very user-friendly. I also put up here use of trained investigators. So investigators who know how to conduct a Title IX investigation again, for use in the formal complaints that are brought. So if you have a parent that really wants to go through a more formal process than just the school dealing with a situation and resolving it, perhaps they're not happy with what happened at the school, that you make sure you bring in somebody who's been trained in how to conduct the investigations, how to conduct that policy violation analysis, how to weigh the burden and come to a conclusion. Suggested training, this is my suggestion based upon my conversations. All staff, I would say, some kind of exposure to Title IX law and guidance and what it means. Also, understanding the policies and procedures and what you do here at Beaverton would be very helpful. I think that again, you're lucky to have a lot of good administrators who are just in there getting things done, training each other, working with each other. But it would be helpful to have a broader scope on this. I know that I conduct trainings where I go and sort of sandwich myself in between other training days that people are having. Even just a bit of information about Title IX so people are thinking about it can be helpful. A Title IX coordinator, I mentioned that I think that the responsibilities should be looked at and figuring out what structure makes the most sense here. There's a lot of different concerns, and I know that in other districts where I've looked at their practices, the Title IX coordinator often is an administrator who just gets added as Title IX coordinator and then doesn't really get the support to handle all those responsibilities. So there are a lot of trainings that are out there, online webinars and things like that about what should a Title IX coordinator be doing. Also suggested in the report that Title IX coordinator report annually to the board about what's happening with Title IX. I think that that's a great check for you guys to see what's happening. Also, Title IX investigators really just understanding how to conduct an investigation, a formal investigation, and then there's specific Title IX areas that should be covered under the 2017 guidance. They talked about addressing bias and stereotypes. And the prior guidance, although rescinded, talked about two other issues that I think are important. One is how to deal with victims of trauma and how that might impact credibility determinations in your investigations, as well as cultural issues and how they can impact your credibility determination. So although that is not contained in the 2017 guidance, I still think it's valid for your investigators to take a look at those things. So that's it. So I'm now available for questions.
Well, thank you very much, Megan, for that thorough explanation as well as the audit that you provided us earlier. So do any board members have questions that they'd like to ask Megan? Tom?
In terms of training, how periodic should those trainings be? And in terms of maybe the all staff, and then also in terms of the more targeted ones for like your HR professionals or your administrators?
I think that the Title IX, the overview of Title IX, I would say best practice would be annually. I think that you could do something with all of your staff less than annually, and there are a lot of insurance carriers that have training programs that you can go around sexual harassment, things like that, and they're often offered to districts at no cost, no additional cost. And they're great for tracking purposes to give people at least an exposure to Title IX. As far as the investigators, I think the investigators getting training annually is important, and that's definitely something that the guidance supports, as well as a Title IX coordinator.
And do you have any preference in terms of the delivery of that training?
Well, for investigations, I think a face-to-face delivery is probably the best, because working through scenarios and how you're going to take information, make a credibility determination, and then write that final report, that seems to be, from my experience, a practice that you have to kind of sit down and really work through those things. I think for the Title IX coordinator and the staff, I think you could do that online or a webinar or something like that. I don't know if there's any organizations on Title IX coordinators in the districts in the state, but that also is a great opportunity to have people come together and work together and get to know each other. We just started a small group in Northern California so that we meet every other month and have an online webinar. Someone takes a topic, and I could even see if you guys want to get invited. But I think it's a great, sort of building that network is really important.
Thank you. This was a great report, by the way.
Oh, thanks, Tom. I mean, Mr. Collette.
Any other questions? Yeah.
Megan, my report was marked with just tons of things that I just felt like were really valuable learnings for me personally. One thing that I'll be frank, I was surprised to see you call out so early and so boldly was that our non-discrimination statement did not satisfy what, and I would have thought that ours were kind of legally compliant. So I was curious if you could just help educate us a little bit more about what things you would have expected to see that you didn't.
So the non-discrimination statement, the guidance on that started in 2001 and evolved, and it became something that OCR sort of added to. And the guidance in the 2015 guidance on the Title IX coordinator went into some more specifics. It probably would be adding the OCR office contact. So the idea is, if you don't trust your school district, where would you go? And your notice will make sure everybody knows that by putting something in there about the local OCR office. Also, there's some specificity around where the offices are located, making sure an email address is available. Again, I think really simple little check boxes. We had a visit at my district by OCR, and that was something they were very interested in, knowing where the notices were posted. So we actually drew a map at the different schools with X's of where they were located, and then we conveniently walked past those X's on our walk through campus. But it actually helped people. The administrator said, I like that we drew this map, because now next year when I have to repost something, I know where to go.
Any others? I know, the thing that occurred to me is, I think we shared with you that we just got done with a 1.5-year long process of reviewing our policies.
Yes.
And we worked with our Oregon School Board Association to help us through that process. So my first question is, do you have any place that you could share that you think another school district anywhere in the country that is using best practices of the most cutting edge language and that sort of thing that you could, because it's obvious that we're going to now, our policy committee, it's got some more work to do to update some policies. But we did just work with our school board association, so I plan on sharing this with our school board association. And Leanne here is the president of the Oregon School Board Association, so I think this could be something that we could, share statewide.
Yeah, and I think policy drafting is one of the most tedious things you can do to try and be inclusive of everything. Everyone agrees with that. But when you look at it with one lens, sometimes you're missing the other lens. So I'm sure that the review was accurate, and then I came in with this Title IX lens. I would say we had all of our policies developed. Of course, remembering that I'm in California, so the California Code defines some of it. We had to meet a lot of policy changes, so I'd say our policies are good because they reflect our resolution agreement with OCR. And I would say other districts that have been through the OCR process and resolution agreement usually change their policies. So if you're looking at the regulatory area of Title IX, looking at school districts that have been through the process probably will point you in the direction of other ones. I don't know off the top of my head of districts in Oregon that have been through that, but I would be happy to research it and get back to you.
We always like to take from others that...
Well, and I do think policy drafting is, it's a necessary evil, but it is exhausting to try and figure out how to be inclusive of everything in a policy. Why a lot of colleges and universities after the 2011 guidance just did a standalone Title IX policy, because there were so many changes that had to be made to so many different policies. And the way they dealt with that was what I was suggesting, which is they put exclusions in the other policies that kind of overlapped. And I think that might be an easy fix for your policies. Just to you want people to go through the same process bucket, I think, and make sure that everybody, I called it in my report forum shopping, which is kind of like, I want to go to the state court or federal court because one's going to be better for me. With your process having 4 steps that take you through up to the board. I don't know that there's a benefit to one or the other, although I think the non-discrimination policy requires you to do something informal, which some people might not want to do as a first step. But I think it's after all the work you've done, I think it can be fixed. You just want to make sure you know where people are going, and people want to know where they should go as well.
Well, I mean, I think because we have done a lot of work on our complaint process as well as having to change, comply with the state level on complaint process, and it's a little bit harder for school districts that are larger versus, but we do want that, our community to know, go into our website where they can find this information and make that as transparent as possible. So.
And your complaint process is on the website. I just would say that sometimes when the website's kind of dense as far as written materials, sometimes people go like, I'm not sure what to do next. That's why the flow chart might just help people work through the process.
Tom?
Yes. Two quick questions. The first one, you alluded to, the board is not normally the final adjusting body for the grievance procedure. Who is normally?
I've seen it go up to the superintendent, not to all the way to the board, particularly around students, because the board only, in the districts I'm thinking of, the board only hears something that would be an expulsion. It only gets all the way up to the board in that level.
Okay.
But it's more along the disciplinary track as opposed to an appeal of a policy decision. It would be just that piece on discipline.
Okay. And then, second question, you stated here in your report the disconnect between human resources centralized at the district offices while a complainant is located at a school site may explain some of this difficulty.
Yeah.
It kind of in reference to how we're dealing with complainants' needs, right? That's the difficulty. We're a very large district, right? Mm-hmm. Do you have any suggestions for how we coordinate across all of our different sites so that we're able to deliver, a consistent response to our students, to our staff, to everybody in the community around this issue? And I understand the piece around getting the Title IX coordinator, like that makes sense to me. Are there other things that large districts do though?
I think that having some forms that help with regard to the interim measures, what you can put in place right away, like a no contact directive or no contact consent agreement. I like to say directive because I don't want anybody to have to consent to it. But having some forms that we get a complaint in that's Title IX and these are the things we're going to do right away. I think understanding what interim measures are and how to put them in place has been a real disconnect at many of the districts I've worked with, in part because interim measures says something very different than what we're used to with students and due process, which is you can do something that seems somewhat disciplinary before you've made a decision about whether a policy has been violated. So I know that, for instance, 2 students being in a class and we have a complaint against one student B and student A wants student B out. I've talked to schools and they've said, well, we can't put student B out because we don't know that they did anything. Under interim measures, you can while that investigation is pending. So I think maybe a greater understanding of what interim measures can be put in place, and it really can be anything that makes sense in the situation. And then having somebody be that point person at the site to check in with that student, make sure things are going well, or at least that you're keeping records that you've been checking in with the student, even if you don't find out that things are going well, sometimes students won't share that, but that you've been checking in regularly with that person. I spend a lot of my time as a Title IX coordinator checking to make sure that those interim measures are in place because they are so important and they get a lot of attention from OCR.
Thank you.
Great report. And so my question isn't to you. It's maybe to the chair and to the superintendent. Where do we go from here? Will it come back with recommendations? Are we going to talk about it again? Do we know? I know I'm asking kind of jumped ahead, but I thought it was such a great report. I want to make sure we do something with it.
It's definitely not going to go on a shelf. I think that the staff may have some input, but I believe the next thing where this will go to first is the policy committee. And then that discussion will happen at the policy committee, and then
Yeah, thank you for the report, Megan. So I have a question for you. In school districts that you've worked with, or other institutions you've worked with, you mentioned it's really important in certain cases to have trained investigators, and maybe even from the outside. In your role that you serve in, is that usually the Title IX coordinator making that call when they want to bring someone in, possibly from the outside, if they don't have those internal investigators within their own organization?
Yes, I often go and have this discussion with our deputy superintendent when I feel this is not something that we should handle internally. There's a lot of reasons for it, and then the other piece of it is there's a lot of considerations. Who are we going to go to? How quickly can they resolve it? Because timing is usually a challenge when you're working with someone externally. And what's the cost going to be? Because the cost can be, I can assure you, astronomical. If you want to look back at the board minutes from Palo Alto, I have an investigator on site for the year because of how high our external investigations were made. But I think that the Title IX coordinator can have a feel for what is this issue? Is it really something that we need to bring somebody externally in? What could be the fallout of this, and when do we really need? We want to make sure that this report is going to, pass muster externally, and sometimes independence is important.
Thank you.
Any other last questions? Well, Megan, we thank you so much for making the trip from Palo Alto and for your time and producing this great report. And I hope that if we have any follow-up questions that we can email or call you. And I know we'll work closely with the HR team and we'll follow through. But you gave us a great roadmap, and it was just really good to hear from outside area that we're doing some things well, but there's always things that we can improve upon.
Absolutely, and my hope is that it would give practical guidance, and I hope it will, and I'm available if there's any questions. I just reiterate that I really do think you have great staff working here and really dedicated to students and doing the right thing. I had the opportunity to meet one of the parents here who also is very dedicated to supporting the school, and I think that says a lot about your community. And so I just wish you all the best, but I'm still out here if I can provide any other assistance.
Well, thank you. This concludes our work session. We're going to adjourn until 6:25 when we will have a budget hearing.